Hello, beautiful family. How are you all doing? Thank you for the love, the support. I just can't thank you enough. So, my beautiful people, today I have a quick one to share with you. Okay, Trust Progress, the analyst. I am here for you to give you all the update back to back. The purpose why you have me is for me to update you, and that is what I am doing. So, please do well to share our videos, like and subscribe. Without not wasting much of your time, let me leave you to listen to this update, and I'll be right back.
Another question, Barrister. Barrister, I hope you can hear me.
I'm hearing you very loud and clear.
All right. All right. Okay. Let's come to the D-Day now regarding the issue. The on 15th of this month, 15th of this month, which is the Supreme Court ruling. We know that you have passed through tough time, and a lot of things has happened in defending our leader, Mazi Nnamdi Kanu, and the IPOB. This is your right as a legal practitioner in Nigeria, but we understand what is behind it. What is the expectation? What is the expectation? What is the expectation will it be regarding that day on the judgment? What do you, by the Biafrans, what are we going to see? What do you think is what we are going to, what is our expectation on that day?
Okay, thank you. It's very unfortunate that we operate a system where people are asking questions of this nation. We operate a system where people are begging an arm of government to respect court orders and also to do the needful. It's important at this point in time to make this clear. So I've repeatedly said it in some of my press releases and interviews granted to mainstream media in Nigeria. But I wish I was speaking in a very low manner so people understand what I'm saying. As very unfortunate as it is, Mazi Nnamdi Kanu's case is first of its kind in this country, where a court of superior decision, in this case, Court of Appeal, Intermediate Court of Records, delivered a judgment and directed for a citizen to be released unconditionally, one, for there to be no further trial on any form of indictment concerning that citizen, for there to be no further detention concerning that citizen. Then the government went on appeal. Without going into the merit or otherwise of the appeal, this has never happened before since the history of my practice as a lawyer in this country. As a matter of fact, there's no legal jurisprudence, there's no legal decision, there's no deciding authority that authorizes a state to appeal, to file an appeal of this nation. Because the law is right and clear. When a citizen who is being prosecuted or who is being, prosecuted on a criminal matter is discharged in the circumstance in which Mazi Nnamdi Kanu was discharged, amounting to acquittal, the person will naturally, assuming the person was in court on the day the pronouncement was made by the court, walk free from that court without being interrupted, intercepted, or arrested by anybody, sent to his house. This is the system. This is how it operates. I've not seen where a court will say, we decide that someone has no case to answer, or someone is discharged and acquitted, then the person, a government prosecuting, will appeal. And on top of that, continue to detain the person. It hasn't happened. Now, a charge was brought against him before the Federal High Court. On application led by Professor Michael's team, the court struck out 8-count charge out of the 15-count charge. Unsatisfied with many counts, an appeal was filed against the remaining 7 count charges. Federal government responded. The appeal was argued on the merits, and the court upheld our appeal and consequently struck out the remaining 7 count charge. The court did not only struck out the remaining count charge, the court discharged Nnamdi Kanu of any further indictment. Even after striking out that 7 count charge, the court proceeded to rule to direct the federal government to release him unconditionally. The court further proceeded to direct the federal government not to entertain, not to file any charge or indictment against him as Nnamdi Kanu in any court in Nigeria. Ordinarily, what's expected in the circumstance is for the federal government to comply with the order of the court without further ado. But it's important for me to also mention that when this was going on, when that judgment was delivered, the federal government took 2 far-reaching steps to circumvent the judgment delivered by the Court of Appeal. One, on that day, the judgment was delivered, being 13th of October, 2022. The federal government went to State Court, Federal High Court, and filed a fresh charge against Nnamdi Kanu. And when this charge was filed against him, it was given to the press to announce in their usual manner, and it was widely published. We're not served with this charge. Now, 2, they filed an application to stay the execution of judgment delivered by the Court of Appeal. So, on the following day, when the matter was slated for a report of the outcome of the proceeding before the Court of Appeal, the following week, we went to court. Then the court was also giving the judgment of the Court of Appeal that said, you should not be tried before any court. You should not be further detained. It should be released unconditionally. Then the court said, I don't have jurisdiction to entertain the charge. Okay, let us have the charge. They didn't have the charge. And the court consequently struck out that fresh charge they filed against him. That's number 1. Number 2, they filed an application to stay the execution of the judgment of the Court of Appeal. And I've mentioned it here. I've said it in several forums. I've also said it in various Nigerian media houses. That there's no legal authority, both statutory laws or case laws, that authorize the staying the execution of a judgment that's discharged and in the circumstance of that judgment acquitted a citizen of crimes indictment against him. This an application to stay the execution of the judgment was purely predicated on civil provisions of the Court of Appeal rules. Civil provision of the Court of Appeal rules. No criminal provision, because what we're talking about is criminal proceedings before the Court of Appeal. And courts sitting by presided over by a different panel this time around, granted this unprecedented order. Same with the Court of Appeal. We then proceeded. The appeal against the judgment of the Court of Appeal. Then the court, on a different panel, now before a different panel, the court granted the order, staying the execution of the Court of Appeal. Now, when this was done, the federal government went to sleep. They practically abandoned the appeal before the Supreme Court. They didn't file the appellate brief within the time specified by the same court. That court that granted order had a time limit within which the federal government is to file the appellate brief and transmit record. They didn't file the appellate brief. As a matter of fact, the transmission of records to Supreme Court was done at our own prompting, because they abandoned everything and left. Because what their intention is to keep now the kind of special distinction before the NSSS. The compilation of the record of the Court of Appeal to Supreme Court was done at our own prompting. They didn't file appellate brief within the time stated in the ruling delivered by the certified true copy. In fact, as a matter of fact, as stands today before judgment coming up next week, the government didn't serve us the appellate brief the first file. They didn't serve us that process because we got it via an application for certified true copy to the Supreme Court before we were able to to be given a copy of what they filed. And we responded. All this we articulated in process before the Supreme Court, and was exhaustively argued by Professor Michael Sekome during the address. So when the matter came up for hearing, we have a lot of applications, so many applications before the Supreme Court. One for transfer to a correctional center pending determination of the appeal. 2, bail. 3, for medical medical for doctors just to see him. So this application, in line with the extant rules of the court and practice, we are all disposed of. Then, and also an application for extension of time to file their appellate, which they file out of time, and also an application to regularize what they filed. So on that day, they also came up with another application, which was served on us a day before the date set for the hearing. What's this application about? Application to amend their grounds of appeal, and also to deem the grounds of appeal amended as properly filed and served. When we look at this application before the court, then let's take Professor Michael Zekome also. After we put our heads together, we understand that the essence of what they're doing is to buy time. It's to buy time, because there was no difference between what they filed before and what they're asking the court to amend for this, or what they're seeking court to amend. It's just to buy time. And we said, no problem. Go on. We're not opposing. Go on. We're not opposing the application. So we can be able to put in our response, amend our response to accommodate what them, to reflect our direct response to what is filed. So that was done, and the matter was adjourned for hearing. On the date he came up for hearing, they told the court that they were unable to respond to our reply brief, despite the fact that they have sufficient time to do that. Even while coming to court, they came with a draft copy of what they have. Let's say Professor Michael Zekome, all the court allowed them a standard to enable them filing, to file what they have in court. They said, no, even if a standard is granted, they cannot be able to file all this process. They want to time. So the matter was adjourned for the fifth hearing. Unfortunately, this matter came up. It was to come up for this hearing. The court was on vacation. The court was subsequently adjourned to October 5th for hearing. And as God may have it, it has been had awaiting judgment. So what I'm trying to say in effect is that in a system where there's respect for rule of law, where rule of law reigns supreme, I don't think we have any business before the Supreme Court in the first place, whatever. I don't think the federal government have any business going to Supreme Court to challenge the decision of the Court of Appeal without reason as an ambiguity. So these are concurrent findings from Federal High Court to Court of Appeal. And incidentally, judgment of Court of Appeal is a unanimous judgment by the 3 justices of the Court of Justice of Appeal. Unanimous judgment delivered by 3 justices that sat on the matter. I know how difficult it is to obtain it. A judgment, first of all, delivered by Federal High Court, also upheld and further full judgment delivered by full panel of judges of Court of Appeal. So what we are urging the federal government and the Supreme Court to do is simple. We are there on law. Appeal has been filed. Decision be given on law. We don't want any form of political influence on the other. And I believe most strongly that just the Supreme Court will do justice to the judgment of judgment coming up on Friday next week. My expectation, I don't think I've lost confidence in judiciary. I don't think so. Some people are insinuating the otherwise, but I don't think so. Because if I've lost confidence in judiciary, I don't think that I'll sponsor a child, my first child, who's reading law today in university. I won't ask her to go and read law. I'll ask her to go and read other courses. But I believe I have some hope and some confidence in the panel that sat on this matter. And I believe that justice will serve. Nnamdi Kanu today is being detained unconditionally, unconstitutionally, illegally, and in gross violation of his extant rights as contained in the Constitution. So I don't think that my justice of the Supreme Court will look other way when the law speak otherwise. I have so much confidence in them, and I believe that justice will serve come 15th of December 2023. And I want to urge every one of us to remain steadfast and calm, believing that justice will be served. Nnamdi Kanu has suffered. he has been tortured emotionally and otherwise. Today, I don't want to go into sentiment because if I say the same Ejiofor is saying, if Nnamdi Kanu is from the north, this will not be happening. If it's from the south, this thing will not be happening. We have seen cases where someone was arrested in another state, another country, and upon the assumption of office by the president of this country today, 2 months after, he was released. And today he's agitating for Yoruba nation. Today he's asking for that. They have been released. So if I say I may not be faulted if I'm to say that Nnamdi Kanu is being detained today because an Igbo man. Simple. I don't want to whip us, but that has to be said. I may not be faulted to say that he's being detained, being tortured, being kept in the worst form, being exposed to all forms of human degradation where he's being detained because of an Igbo man. I may not be faulted because the facts are there. So what I'm urging the federal government, what I'm urging the judiciary, I don't want to believe that the executive will have influence over the judgment of 15th of December. I don't want to believe that. I want to believe most strongly that my confidence on the judiciary and my knowledge of the Supreme Court remain unshaken.
So, my beautiful family, that brings us to the end of this update. Do well to like the video, share, and subscribe. I still remain your one and only Progress the Analyst. I give you all the update back to back. Thank you so much, and bye bye.